Ready to roll. We're ready?
Yes, sir.
All right, good morning, everyone. This meeting is called to order. Mr. Trollman, has anyone signed up for public comment? Thank you very much, Mr. Trollman. Good morning, Ms. Miller.
Good morning, sir.
How are we today?
Very well, thank you.
Good. We have no cases to reconsider under agenda item 3. Is that correct?
Correct, no cases.
Let's move to tax liability cases under agenda item 4. I believe we have 2 tax cases on docket 24.
Yes, sir. The first case is TD-19-053-0319. Commissioner Demerson,
Agree with staff recommendation.
Commissioner Alvarez.
I agree with staff's recommendation.
Mr. Chairman.
Agree with staff recommendation.
And the second case is TD-20-062-0320. Commissioner Demerson,
Agree with staff recommendation.
Commissioner Alvarez.
I do not agree with staff's recommendation. The employer has been granted multiple motions for reconsideration and hearings have been postponed per their request for over 2 years. Although the employer alleges they were not given the opportunity to present relevant evidence due to open records problems, they have admitted that they did not have any other evidence and do not believe any specific documentation is being withheld. The act only allows the extension of tax payment due to due date with a showing of good cause. The employer has not shown good cause in this case. Deny the motion for reconsideration.
Agree with staff recommendation.
Thank you.
Short form dissent.
Yes, sir. That was the last tax liability case on docket 24.
We have no fair housing cases under agenda item 5.
Correct.
Under agenda item 6, we have no wage claim cases on docket 24 pulled for additional discussion.
Correct. None pulled for discussion, but you should have received the wage claim short form dissent list for docket 24.
I move we accept staff recommendations on the remaining wage claim cases on docket 24.
I second the motion except for those cases of which I'm dissenting as reflected on the wage claim short form dissent list for docket 24.
I concur with the chairman's motion except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for docket 24.
Motion passes with the exceptions noted. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 24. Please proceed when you're ready.
The first 14 cases will be called together. Case number 296-9154, case number 296-9159, case number 296-9240, case number 297-9369, case number 297-9417, case number 308-4130, case number 308-4227, case number 308-4232, case number 308-4255, case number 308-4271, case number 308-4379, case number 308-4387, case number 308-4391, and case number 308-4416. Commissioner Demerson?
The AT decision in each of the 14 companion cases in this group is not supportable. Although the employer filed a late protest to the notice of maximum potential chargeback in each case, the employer's witness gave credible and consistent testimony that the company was misled by what it perceived as assurances from TWC and other officials that no protest was necessary due to the pandemic. Legitimate confusion over misleading advice from TWC qualifies the employer for an exception to the timeliness rules. Thus, the employer's protest to the NMPC in each of these companion cases should be considered timely, and the employer is entitled to a review of the merits of the chargeback issues. Since the decisions must be based on the reason why each claimant stopped working for the employer before the initial claim was filed, and the available record does not reflect those reasons, the cases will have to be resubmitted with a discussion of why each claimant stopped working for the employer prior to the initial claim. With that information, we can determine whether the reason for the work separation in each case qualifies for chargeback protection under section 204.022 of the Act. Accordingly, we should reverse the AT decision on the late protest issue, hold each protest timely, and resubmit the cases on the merits of their respective chargeback issues.
The decision is supportable. The employer has alleged they did not respond timely because TWC issued press releases stating there would be no chargeback for claims filed due to COVID-19. TWC did not inform the employer it should ignore TWC communication or that they did not need to protest notice of maximum potential chargeback. Claimants have filed late appeals where TWC messages lead them to believe they did not need to appeal. They have not been provided the same leniency the employer seeks here today. Affirm the AT, the employer filed a late response to the notice of maximum potential chargeback.
Reverse the AT, timely response to the NMPC, resubmit.
Thank you. We will resubmit these cases.
Case number 2763683, Commissioner Alvarez.
The claimant delivered food for the employer, a delivery service app, and was not engaged in employment. The claimant was engaged in self-employment. As such, there was no separation from employment and the determination is void. Void the continued claim dated February 13, 2021.
We should affirm the AT decision. The claimant was discharged when the employer's background check revealed that she did not carry the requisite insurance for the job. Since the record indicates that maintaining insurance was an essential component of the claimant's job duties, her failure to maintain proper insurance constituted mismanagement of her position of employment and was misconduct connected with the work. Hence, we should affirm the AT decision, misconduct. In the alternative, before rendering a decision in this case, we should hold this case pending guidance from the Office of General Counsel on whether additional claims and continued claims should be voided solely because the last work was not in employment.
Void continued claim.
The majority vote is to void the continued claim.
Now I'm going to short form this.
Yes, sir.
Okay.
Case number 2827914, Commissioner Alvarez.
The on-the-record decision in this case is not supportable. A determination found that the claimant failed to provide proper SSN information and voided her claim. The claimant filed a timely appeal disputing the merits of the determination. Instead of holding a hearing to address the matter on the record decision, was issued affirming the original determination. This is a violation of the claimant's due process rights, and the case should be remanded to the AT to properly address the appeal. Remand.
The claimant's appeal to the commission was late. No recognized exception to the appeal deadline applies. Accordingly, we should dismiss the claimant's appeal to the commission as late. The AT decision that the claimant's initial claim was invalid is left in effect. We should also send a memo to UIA and OS to contact the claimant concerning the Social Security number issue to give her an opportunity to file a valid claim.
Late commission appeal, the AT decision remains in full force and effect. Memo is recommended by staff.
Short form of dissent.
Commissioner, Mr. Chairman, could you repeat your last sentence?
Memo as recommended by staff.
Thank you.
Case number 2827916, Commissioner Alvarez.
The on-the-record decision in this case is not supportable. A determination found the claimant failed to provide proper SSN information and voided her claim. The claimant filed a timely appeal disputing the merits of the determination. Instead of holding a hearing to address the matter, an on-the-record decision was issued affirming the original determination. This is a violation of the claimant's due process rights, and the case should be remanded to the AT to properly address the appeal. Remand.
The claimant's appeal to the commission was late. No recognized exception to the appeal deadline applies. Accordingly, we should dismiss the claimant's appeal to the commission as late. The AT decision that the claimant's PUA claim was invalid is left in effect. Send a memo to UIA and OS to contact the claimant concerning the Social Security number issue to give her an opportunity to file a valid claim.
Late commission appeal, the AT decision remains in full force and effect. Memo as recommended by staff.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 2885130, Commissioner Alvarez.
Regarding good cause, the claimant was sick on the date of the hearing and unable to participate. Regarding the timeliness issue, the claimant has presented testimony and documentation that he attempted several fax appeals during the deadline, which were not completed due to the TWC's busy signals. Employers in similar circumstances have had their appeals found timely. Since the claimant was unable to complete his appeal because TWC systems were overloaded, His appeal should be deemed timely and the case resubmitted for merits. Good cause, timely appeal, resubmit.
The appeal tribunal decision should be modified. I agree that the claimant established good cause for his non-appearance. As to timeliness, the claimant's appeal was filed beyond the applicable deadline to do so. There are no good cause exceptions to the timeliness rules. Accordingly, we should modify the AT decision. The claimant had good cause for his non-appearance. Untimely claimant appeal, leave the underlying decision in full force and effect.
Modify the AT, claimant established good cause for AT1, untimely claimant appeal, voluntary leaving, overpayment.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2926229, Commissioner Demerson.
The AT decision is not supportable. On previous dockets regarding similar cases involving the same employer, I noted that lack of proper information can be just as misleading to a party as improper information that is given to a party. In other words, misleading a party by omission or relevant information should be treated the same as misleading a party by supplying wrong information. In this case, the employer was not told on the notice of maximum potential chargeback that it could have dealt with its claim volume problem by simply sending TWC a spreadsheet of all of the NMPCs that it needed to protest. That is certainly an option that is available, and it should have been mentioned on the NMPC, particularly in the context of the pandemic when claimants, employers, and TWC were all overwhelmed by the volume of claims, appeals, and related proceedings. If the employer had the proper information, it could have responded to the chargeback notice on time. Regarding the chargeback issue, we have testimony from the employer that the claimant quit her last work without giving a reason while continued work was still available. Accordingly, we should reverse the AT decision. The employer filed a timely response to the chargeback notice, protect the employer's account from chargeback.
The AT decision should be affirmed. The agency mailed the notice to the employer's correct address of record, and the notice stated the deadline to respond. The employer admitted receiving the notice timely and also admitted to then filing the response late. The employer testified that the late filing was due to their staffing shortage, which is a circumstance completely under their control. There are no good exceptions to the timeliness rules. Affirm the AT, no timely protest, chargeback.
Reverse the AT, timely response to the NMPC, no chargeback.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2935051, Commissioner Demerson.
We should reverse the appeal tribunal's good cause decision. The employer did not receive the hearing notice for the AT1 until after the hearing date had passed because it had mail issues after its mailbox was damaged. As such, the employer established good cause for its non-appearance, and we should resubmit the case for merits testimony. In the alternative, we could grant a rehearing as the record was not sufficiently developed for us to render a decision in this case. Regarding the damaged mailbox, we need to establish when the employer's mailbox was damaged and its relation to the date that the hearing notice was issued. In addition, in its appeal to the commission, the employer alleges that issues with the agency's online account prevented the employer from updating its address with TWC. Accordingly, we should rehear to establish when the employer's mailbox was damaged and to further develop the record on the employer's effort to update its address with the Workforce Commission.
The AT decision should be affirmed. Regarding the issue of good cause, the employer was mailed the notice of hearing to its correct address of record. The employer testified that it had changed its address but did not notify the agency of the new address because it did not think it was needed to do so. A party's failure to update its correct mailing address with the agency is not good cause for failing to appear at a scheduled hearing. Regarding the separation, the available record indicates that the claimant was fired for performance issues, but the employer made no allegations specific enough to support the findings of misconduct. Affirm the AT, no good cause, no misconduct, chargeback.
Rehear.
We will rehear the case.
Case number 2938022, Commissioner Demerson.
The AT decision is not supportable. Concerning the late protest issue, the employer's response should be considered timely since the company was effectively misled by omission of important information. Specifically, the employer was not told on the notice of maximum potential chargeback that it could have dealt with its claim volume problem by simply sending TWC a spreadsheet of all of the NMPCs that needed to protest. If the employer had had the proper information, it could have responded to the chargeback notice on time. Regarding the chargeback issue, we have consistent documentation from the employer that the claimant quit her last work to accept another job while continued work was still available. Accordingly, we should reverse the AT decision. The employer filed a timely response to the chargeback notice, protect the employer's account from chargeback. Alternatively, I would agree to holding the employer's response timely and having the case resubmitted on the issues of whether the employer is entitled to chargeback protection based upon the reason for the work separation.
The AT should be affirmed. The agency mailed the notice to the employer's correct address of record, and the notice stated the deadline to respond. The employer admitted receiving the notice timely and also admitted to then filing the response late. The employer testified that the late filing was due to their staffing shortages, which is a circumstance completely under their control. There are no good cause exceptions to the timeliness rule. Affirm the AT, no timely protest.
Reverse the AT, timely response to the NMPC, resubmit.
We will resubmit the case.
Case number 2990382, Commissioner Demerson.
We should modify the appeal tribunal decision. The employer presented firsthand testimony and direct evidence to establish that the claimant was previously talked to about her negative attitude. Although the claimant was warned about her demeanor during a recent performance review, the claimant was thereafter seen yelling at a subordinate employee to the point of driving the subordinate employee to tears. Since the claimant continued to display unprofessional behavior at the workplace after sufficient warnings, her conduct constituted mismanagement of her position of employment and was misconduct connected with the work. Hence, we should modify the AT decision. Misconduct, reimbursing employer, not billed, sever the adequate response issue.
The claimant was unemployed and filed a valid claim. The claimant was fired because her skills did not meet the employer's expectations. The claimant never demonstrated the ability to meet the employer's expectations as a supervisor, and the employer failed to give the claimant an opportunity to improve her performance prior to her discharge. While the employer provided vague allegations about the claimant pushing back against her supervisors or that the employee had cried when the claimant issued the employee a corrective action, these statements did not establish misconduct. The claimant was fired for her inability to meet the employer's expectations and was discharged for reasons other than misconduct connected with the work. Modify the AT valid claim, no misconduct, bill reimburse an employer, and void the adequate response ruling.
Modify the AT, valid claim, misconduct, reimbursing employer not billed, sever adequate response.
Chair, agree with the chairman. It was a valid claim.
Majority vote is valid claim. Misconduct, reimbursing employer not billed, sever adequate response.
Short form dissent.
Yes, sir.
Case number 3021453, Commissioner Alvarez.
The decision is not supportable. The claimant filed her claim after she was prevented from performing services for the employer due to an emergency, displacement resulting from her apartment complex exploding. Further technical issues prevented her from logging into the employer system. The fact that she later returned to work for the same employer does not make her claim invalid. Regarding her separation, the claimant was displaced from her apartment due to an explosion. She was unable to perform her remote work from another location due to the employer's privacy measures and other technical issues. Approximately a month later, she was able to return to her apartment. The technical issues were fixed, and she resumed working for the employer. The claimant remained in contact with the employer and regularly tried to log into the system. The claimant's separation was urgent, compelling, and necessary. Reverse the AT valid claim, no voluntary leaving, urgent, compelling, and necessary.
We should reverse the appeal tribunal decision. First, because the claimant was partially unemployed when she filed her additional claim, her claim is valid. As to the job separation, the employer provided the claimant a computer on which she could continue to work. Despite the claimant's unfortunate need to evacuate her apartment, although the claimant was having login issues, the employer was working with the claimant to remedy the situation. By filing her additional claim without providing the employer a reasonable opportunity to correct the matter, the claimant is considered to have quit without good cause connected with the work. We should reverse the AT decision. The claimant filed a valid claim, voluntary leaving.
Reverse the AT, valid claim, voluntary leaving.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 308-2009, Commissioner Alvarez.
The AT decision should be modified. I do not dispute the AT ruling on the claimant's backdating request. Also, the ruling on the severance payment should be severed. As to the separation, the employer considered the claimant a non-exempt employee and refused to pay her overtime pay. The claimant believed that she should have been paid overtime and contacted an attorney. The employer eventually agreed to pay the claimant over $55,000 in satisfaction of her claims against the employer in exchange for the claimant's separation from employer. The fact that the claimant was required to separate from her job in order to receive satisfaction of her claim does not change the underlying facts that caused the claimant separation. She quit the job because the employer refused to pay her overtime pay she was entitled to, and the employer paid the claimant a substantial sum in satisfaction of her claim. The claimant had good cause connected with the work to quit when the employer did not pay her overtime. The AT decision on this separation should therefore be reversed. Modify the AT, backdating request denied, no voluntary leaving, chargeback, severance issue.
We should modify the appeal tribunal decision. First, because the claimant had the opportunity to file her claim sooner, but chose not to do so, we should deny the claimant's request to backdate the claim. As to the job separation, while the claimant may have had a concern regarding her pay, she did not bring this concern to the employer prior to quitting. Instead, she hired an attorney to initiate and negotiate her voluntary separation. While the claimant was on vacation during her last week of employment, because the claimant quit without providing the employer a reasonable opportunity to address her concerns, the claimant quit without good cause connected with the work. Accordingly, we should modify the AT decision, deny the request to backdate the claim, voluntary leaving, no chargeback, and sever the severance pay issue.
Modify the AT, backdating denied, voluntary leaving, no chargeback, sever the severance issue.
Short form dissent.
Thank you, Commissioner Alvarez. I have your short form dissent.
Case number 309-3292, Commissioner Alvarez.
The AT decision should be reversed. The claimant had hip replacement surgery and was out of work for 3 months. Her doctor recommended that she take another 3 months, but she attempted to return to work. She was not able to continue working due to her condition. She tried to transfer to a different position, but was not allowed to do so. She quit the job because she concluded that she was physically unable to perform the work. The claimant had good cause connected with the work to quit the job due to her medical condition. Reverse the AT, no voluntary leaving, bill reimbursing employer.
We should affirm the appeal tribunal decision. The claimant quit due to alleged physical and mental ailments and the fear of contracting COVID-19. However, her doctor had not advised her to quit. Although the record contains a doctor's note from the claimant's physician, the note was dated after the claimant's separation. As such, the claimant voluntarily quit without work-connected good cause. Therefore, we should affirm the AT decision, voluntary leaving, reimbursing employer not billed.
Affirm the AT, voluntary leaving, reimbursing employer not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 309-7341, Chairman Daniels.
Because the commission communicated to the public on multiple occasions, including April 1st, 2020, that no employer would be charged based on separations caused by the pandemic, the employer could have reasonably relied on that information and been misled into failing to appeal timely. The employer's appeal should be deemed timely and the case should be resubmitted for merits testimony.
Commissioner Alvarez.
The AT should be affirmed. The employer testified that they timely received the notice, but they consciously chose not to protest because they did not understand that the notice applied to them. There are no good cause exceptions to the timeliness rules. Affirm the AT, no timely protest, chargeback.
So under TWC President, an employer may raise an issue regarding wage credits at any time during a claimant's benefit year. In this case, the employer has raised an issue of wage credits in its appeal to the commission. Although that appeal was filed after the expiration of the claimant's benefit year, that was not the fault of the employer, since the AT hearing and decision were delayed by well over a year due to the tremendous pandemic-related backlog of appeals. Commission appeals is quite detailed and indicates that the claimant may have been an independent contractor, meaning that the late response issue may be irrelevant if the employer was not a base period employer in the first place. Since the employer and the claimant have not had an opportunity to offer evidence concerning the employment status and wage credit issues, and due process requires notice to the claimant of an issue affecting his benefit rights, we should remand this case to the appeal tribunal for notice to both parties of a hearing on those issues.
We've not yet achieved a majority vote.
Chair, what was the chairman's vote?
Mr. Chairman, I believe he voted to find the response timely and resubmit on the chargeback merits.
Let me concur. Chairman, I'm going to agree with the chairman.
Thank you.
Thank you.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3106167. Commissioner Alvarez.
The AT should be affirmed. While the determination was issued during the time when the agency system was overloaded with claims at the beginning of the pandemic, the employer's testimony that they did not have access to electronic documents is not credible because agency records show that the determination was open the day after it was sent. The employer then waited more than 8 months to respond, and the commission has previously voted to affirm late appeals by other parties for such delays. Affirm the AT late employer appeal, bill reimbursing employer.
The appeal tribunal decision should be reversed. The employer was prevented from filing a timely appeal due to a lack of commission resources. The employer's annual period was also inside the window of time the TWC was experiencing technical issues due to the pandemic. As such, the employer's appeal should be deemed timely. As to the underlying job separation, the claimant quit her job for other employment while work was still available with the named employer. Therefore, the claimant quit without work-connected good cause. Accordingly, we should reverse the AT decision, timely employer appeal, reimbursing employer, not billed.
Reverse the AT, timely employer appeal, reimbursing employer not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez. And that was the last UI case pulled for additional discussion on docket 24. You should have received the UI short form dissent list for docket 24.
I move we accept staff recommendations on the remaining UI cases on docket 24.
Chairman, at this time, I'm going to ask for a 5-minute recess regarding one of the cases that we previously went over, if that's okay.
That's okay.
Great. Okay, Chairman. Chairman, thank you for allowing me, and Commissioner, thank you for allowing me recess with my attorneys regarding some cases. Regarding the companion cases, I would request Commission Appeals obtain information from the claimants regarding the job separation. Thank you, Ms. Miller.
One moment, please. Doing so would require us to rehear the cases. Is that what you're requesting, sir? We would need to conduct an additional hearing at which to invite the claimant if that's what the commission chooses to do.
I would agree to that.
Let me make sure I'm understanding what Commissioner Alvarez is asking us to do.
Which cases?
These are the 14 companions we started with. They were all late protest cases, and the vote was to deem the protest timely and resubmit on the merits of the chargeback issues. And if I'm understanding Commissioner Alvarez's request correctly, he's asking Commission Appeals to invite the claimants to provide testimony on the separation issues, the chargeback separations, which would require additional hearing because as these are chargeback cases, the claimants have never been invited to the proceedings.
So this would be in addition to the resubmitting that we're requesting now. This is
Yes,
something
there would
outside of
have to
that.
be rehearings conducted on the 14 separations with the 14 additional, the claimants. Each additional claimant would get a separate rehearing.
Yeah.
And then the case would be resubmitted with recommendations made on the 14 separate
Okay.
separations.
Got it. All right, let me concur with that. I want to stay with what we've asked for here in regards to my vote, which is hold each protest timely and resubmit the cases on the merits of their respective chargeback issues.
Okay, without the testimony of the claimants.
That's correct.
Okay. And Mr. Chairman.
Explain to me our typical procedure in a case like this with no external factors, with any external factors notwithstanding.
Claimants are not invited to chargeback hearings. They're single party hearings involving the employer only.
So in any circumstance, when an employer responds timely to a notice of maximum potential chargeback, the claimants would not participate in that hearing.
Correct. This would be a departure from our normal procedure.
So to offer the claimants, this would be a complete abandonment of our normal procedure?
As you've stated, yes, sir, it would be a departure, sir.
Okay, I'll stick with my original vote.
Okay, Commissioner Alvarez, your motion has not passed.
That's fine. On
Okay.
record.
All righty. In that case, I believe we're ready to.
There's a motion pending to
Yes, sir.
accept staff recommendations on the remaining UI cases on docket 24.
Chairman, with that motion, I second that, except for those cases of which I'm dissenting as reflected on UI short form dissent list for docket 24.
I concur with the chairman's motion, except for the cases on which I am dissenting as reflected in the UI short form dissent list for docket 24.
Motion passes with the exceptions noted.
Thank you.
Thank you. We'll take a short recess. Are we ready? Ready? This is agenda item 8, chapter 835, self-sufficiency fund rules.
Good morning, Commissioners and Mr. Cerna. For the record, my name is Abby Austin with Outreach and Employer Initiatives. Commissioners, before you today, for your consideration for approval are proposed rule amendments to Chapter 835 Self-Sufficiency Fund. In an open meeting on December 21st, 2021, the Commission approved the policy concept regarding the amendments to Chapter 835 rules. The policy concept was posted to TWC's website. These proposed amendments to Chapter 835 will implement Senate Bill 770, passed by the 87th Texas Legislature regular session, to specify eligibility as individuals who are identified by the Commission as being low income or at risk of becoming dependent on public assistance benefits, and to include language on the process for the Commission to establish an income limit for use in determining an individual's eligibility to receive benefits. Considering that the intention of Senate Bill 770 is to expand eligibility for individuals to participate in this program, these proposed amendments will also expand eligibility to youth up to the age of 24 who are part of a low-income family. This proposed change is possible due to recent changes submitted for Texas Temporary Assistance for Needy Families, or TANF state plan, which would allow for the expanded eligibility. Also, Texas Government Code 2001.039 requires that every 4 years, each state agency review and consider for readoption, revision, or appeal each rule adopted by that agency. TWC reviewed the chapter as part of the proposed rule in accordance with the statutory requirement. Staff recommends submitting the proposed rule for publication in the Texas Register for a 30-day public comment period. Staff also requests the ability to make minor non-substantive changes to the document in order to comply with the publication requirements of the Texas Register and the Office of the Secretary of State. This concludes my presentation. I'm happy to answer any questions.
Comments or questions?
None here, Chairman.
None.
Do we have a motion?
I move that we approve the proposed rule amendments for Chapter 835 Self-Sufficiency Fund and post to the Texas Register for a 30-day public comment period.
A second.
It's been moved and seconded. We're unanimous. Thank you. This is agenda item 9, chapter 854 BET rules.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Sedna. For the record, Lizette Hinojosa with Vocational Rehabilitation Division. Commissioners, before you today for your consideration and adoption are the final rule amendments for Chapter 854, Business Enterprises of Texas. In an open meeting on March 22nd, 2022, the Commission approved proposed amendments to Chapter 854 to incorporate revisions approved by the Rehabilitative Services Administration to bring BET rules into compliance with the Randolph-Shepard Act. Proposed rule amendments were published in the April 8th, 2022 issue of the Texas Register for a 30-day public comment period. No comments were received. Additionally, staff conducted a 4-year rule review of Chapter 854 in accordance with the Texas Government Code 2001.039 and determined that the initial reasons for adopting the chapter still exist and the chapter is still needed. Staff recommends adopting the amendments to Chapter 854. Should the Commission adopt these rules, staff requests the ability to make minor, non-substantive changes to the document in order to comply with the publication requirements of the Texas Register and the Office of the Secretary of State. This concludes my presentation. I'm available for any questions.
Any comments or questions?
None here.
Not here.
Is there a motion?
Chairman, I move that we adopt the amendments to 40 Texas Administrative Code, Chapter 854, Business Enterprises of Texas, as recommended by staff.
Second.
It's been moved and seconded. We're unanimous. Thank you.
Thank you.
This is agenda item 10, Chapter 856, VR Services Rules.
Good morning, Mr. Chairman, Commissioner Alvarez, Commissioner Demerson, Mr. Cerna. For the record, Cheryl Fuller, Vocational Rehabilitation Division. Commissioners, before you today for your consideration for approval is a policy concept to amend 40 TAC Chapter 856, Vocational Rehabilitation Services, and specifically Chapter 856.57, to increase efficiency in the process of establishing the annual rates for medical services. Texas Labor Code, Chapter 352.054, Rates for Medical Services, requires TWC to adopt by rule standards governing the determination of rates paid for medical services. TWC is also required to reevaluate these rates annually and to provide notice of the proposed schedule of rates for public comment. Currently, TWC's 3-member commission reviews and establishes the rates themselves. However, it may not be necessary for the commission to establish the rates because the Texas Labor Code requires the commission to adopt by rule standards governing determination of the rates. And these standards are currently in 40 TAC Chapter 856.57. So after reviewing the current process, staff identified that efficiency could be increased by allowing the executive director or deputy executive director to establish the rates for medical services annually based on the standards set forth in rule by the commission. Staff therefore recommends amending 40 TAC Chapter 856.57 to add that TWC's executive director or deputy executive director may establish the rates annually based on the standards adopted by the commission and to include the process for providing the notice of the proposed schedule of rates for public comment. This concludes my presentation. I'd be happy to answer any questions.
Comments or questions?
None here, Chairman.
None.
Is there a motion?
Chairman, I move that we approve the policy concept for amending 40 TAC Section 856.57 as discussed by staff.
Second.
It's been moved and seconded, and we're unanimous. Thank you.
Thank you.
It's agenda item 12, Professional Development Support for Nonprofit Adult Literacy Organizations, RFA approval.
Good morning, Chairman Daniel, Commissioner Demerson, Commissioner Alvarez, Mr. Cerna. For the record, this is Sandra Williams with the Workforce Development Division. Commissioners, before you today for your consideration and approval is a discussion paper regarding RFA 32022-0020, which is AEL Professional Development Support for Nonprofit Adult Literacy Organizations as required by Texas Labor Code Section 315.007D. This RFA sought applications from nonprofit literacy organizations who are not receiving AEL funds either directly or as a subrecipient, and will provide professional development to tutors, instructors, administrative staff, and trainers for nonprofit adult literacy organizations in Texas. Staff recommends awarding $300,000 in one award as laid out in the discussion paper, which is the entire amount allocated for this initiative. This concludes my presentation, and I am happy to answer any questions that you may have.
Comments or questions?
None here, Chairman.
None. Thank you.
Is there a motion?
Yes, I move that we approve the recommended applicant and issue one grant awarding $300,000 for the professional development support for nonprofit adult literacy organizations, RFA 32022-00204.
Second.
It's been moved and seconded. We're unanimous. Thank you.
Thank you.
This is agenda item 14, board nominations.
Good morning, Chairman, Commissioners, and Mr. Cerna. For the record, Cherie Dudley with the Workforce Development Division. For your consideration this morning, we have Workforce Board nominations for Concho Valley, Middle Rio Grande, Permian Basin, and Southeast Texas. Staff recommends approval on the presented nominees, and I'm here to answer any questions you may have.
Comments or questions?
None here, Chairman.
None here.
Is there a motion?
Chairman, I move to approve the board nominees for Concho Valley, Middle Rio Grande, Permian Basin, and Southeast Texas.
Second.
It's been moved and seconded, and we're unanimous.
Thank you.
Thank you. I do not believe there's either a legislative proposal update or a legislative report today. Mr. Cerna has indicated that there's not an executive director's report today. Mr. Cerna, I do have a request for you, though. As we are preparing to implement the action we took recently related to hearings for non-LU based period employers, I'd ask that staff look at, investigate, and find a process similar to what we saw today during the UI portion of the docket, where several hearings with the same employer were scheduled concurrently. Anything else for Mr. Cerna?
None here, Chairman.
None here.
The time is now 9:52. The Texas Workforce Commission is going into executive session in room 250B to discuss the appointment, employment, evaluation, reassignment duties, discipline, or dismissal of the executive director, internal auditor, executive staff, or other personnel pursuant to Texas Government Code, section 551074A1. I better turn that on. The executive session is now concluded and the time is 10:35. Is there any other order of business to come before the commission?
None here, Chairman.
Chairman, a couple of things real quick. I had an opportunity to present at ACC last week, their honor graduation ceremony. And so our AEL program, those that were receiving GEDs and the like, it was very moving ceremony. But these are individuals that have made commitments to try to make a difference in ACC. We're honoring them with the graduation ceremony. Also, thanks, Ed, to the team for our kickoff of Texas Interns Unite, TIU, that initiative with the press conference at the Google facility, followed up with the program chairman. Thank you for participating last Friday on that event. Commissioner Alvarez, we mentioned that you were out that day, but very supportive of the efforts, but an event that went very well with the interns throughout the state. And we're looking forward to future events as we go forward. That's it.
Yeah, I went to the watch party that your interns were hosting just to check to see what was going on. Music was a little loud. I asked him to turn it down, but the refreshments were great. I appreciate you doing that.
Mr. Chairman, in our report on Monday, one of the highlights of their day was the fact that you guys went down there to meet with them. They actually mentioned that in our report. So thank you for doing that.
Oh,
It meant a lot to them.
Absolutely.
yeah.
Anything else?
Chairman, I just, since Commissioner Demerson brought something up, this past last Friday, I want to thank Cheryl Fuller and her VR staff for rolling out the first Apprenticeship 2.0, which Jason Baton was a huge part of. As you know, last year we wrote a letter, or 2 years ago, we wrote a letter to Donald Trump, the president, and asked him if, with some flexibility on pre-ETS funding to allow these individuals with a disability to explore various careers that were out there available to them. Their first trip was to NASA, and I had an opportunity to travel with these students on a boat at the Port of Houston. So I wanted to take this opportunity to thank Cheryl Fuller. Cheryl, thank you for allowing us to work with Jason Baton on this. As I know, there's only one other entity besides San Jack that got awarded. And unfortunately, I won't be able to make the next tour. But just so that you know, Ed, we're the only ones in the country that are actually doing this. The Secretary of Labor allowed TWC an opportunity to try this as a pilot program, if I'm not mistaken. So please let staff know that. That's all I got, Chairman.
Commissioner Alvarez, I'd love to get more information on what that initiative sounds like.
They got one more event.
Okay.
So,
Is there a motion to adjourn?
Chairman, I move that we adjourn.
Second.
It's been moved and seconded to adjourn. We're adjourned.